Good afternoon, one and all present here. Myself, Huma Khan, Assistant Professor, Faculty of Law, Integral University. Welcomes you all to the fourth technical session of the Module 1 of the Faculty Development Program on Emerging Trends and Administration of Criminal Justice and Forensic Science. Our today's topic is Pathways into the Criminal Justice System for Individuals with Intellectual Disabilities, Human Rights Perspective. As we all know that people with intellectual and developmental disabilities have disproportionately negative experiences in criminal justice system as both as victims or as well as accused. It is felt that people with these disabilities should be treated with more respect and their disability merits more attention in the criminal justice interactions. Further, to deal with this topic, we have our honorable resource person, Dr. Sachin Sharma, sir, with us. Sir is Associate Professor of Law at Himachal Pradesh National Law University, Shimla. Before joining this institution, he had served as Assistant Professor of Law at the Rajiv Gandhi National Law University, Punjab, National Law University and Judicial Academy, Assam, Symbiosis Law School, Pune, MATS Law School, Raipur. Sir has cleared UGC NET, completed PhD from Nalsar, Hyderabad, and BA LLB from University Teaching Department, Barkatullah University, Bhopal. Apart from this, Sir has also completed a short course on research methodology, teaching department, Barkatullah University, University, Amsterdam, Netherlands. Sir has keen interest in philosophy, disability, jurisprudence, healthcare, and gender sexual studies. His primary area of interaction includes legal theory, and public law. He used to interact with students on subjects including law and weaker sections, law, poverty and development, jurisprudence, law of tort, interpretation and constitutional studies, etc. Apart from his academic interest, he is also associated with action research in disability studies. So welcome you, sir. Kindly enlighten us with your lecture on the topic.
Yeah,
Over
thank you,
to you,
thank you,
sir.
thank you so much, ma'am, for such a warm and lengthier introduction. So it's my honor and privilege to be the part of this session and to deliberate on this very, very sensitive issue of the criminal justice vis-a-vis the people with disabilities and particularly people with intellectual disabilities. So first of all, I thank the organizers, the entire team, the vice chancellor, and the whole facilitator for this program. And particularly, I would like to thank Dr. Junaid for in giving me this invite and asking me to deliberate on this area, this topic. So as I think it is clear from the introduction from my of my experience that I am not a person coming from a criminal justice or criminal jurisprudence. So I have expertise, if I can name it's within the disability circle. So my focus here is primarily at to analyze, to understand, and try to communicate on the principles of justice, particularly criminal justice, and its relation and impact with person with disabilities. Now, before we go into the specifications of our topic, is I'm audible, ma'am? Is my voice is clear? Hello, whether I'm audible or not?
Yes, sir, you are audible.
Okay, okay, thank you. Okay, now as I said, okay, like let's firstly go through a background. Okay, as in the introduction itself, it is stated that when we talk about people with intellectual disability and criminal law, so either they are as a victim or as a suspect. So my focus primarily on the part of victim or victimization of people with intellectual disability, that whether our criminal justice system or criminal law is equipped enough to deal with the situations related to or the conditions related to persons with intellectual disabilities. But before we go into this background, firstly I would like to start with the basic idea about the components of criminal justice system. So if you see the component or the basic features, you can say, of criminal justice system, so there are three basic components. So they are law enforcement, courts, and corrections. Okay, so I think everyone will agree on this point that when we say law enforcement, here we are talking about the police system, police administration, that whether the police system or administration of a particular country or a state is, equipped to tackle the situations, or is okay, and it includes so many things. Second component is court, where ultimately the justice will be served or delivered. So whether the courts are, performing their jobs, diligently, particularly in the area of people with intellectual disability when they are coming in, in any issue related to criminal law. And third is the correctional homes or corrections, so which are the prison system. Okay, so whether our prison systems are inclusive enough. So all these three things, law enforcement, court, and corrections, corrective homes or correctional homes, these three things are the first question for us, whether they are inclusive enough to accommodate a person with disabilities, and particularly person belonging to a socio-psycho disabilities or intellectual disabilities. Now, if you see in journal, if these three, components are working perfectly and working in harmony, then there is, all possibility ki our system is doing well. But if there is any lack or any gap between these three components, then there could be the, various issues related to administration of criminal justice. So ultimately what is most important is that the people who are running these three components, or who are the part of these three components. Okay, so for instance, when we say people, so like people who are the people dealing with the police department or working in courts or in prison systems, so are whether they are value oriented. So this is my first parameter, that if people are value oriented, based on, their ideas are based on the principles of equity, equality, dignity, and respect, then automatically they will be, able to create an inclusive model of criminal justice system, which will easily accommodate a person with intellectual disabilities. Because at the end of the day, what is the purpose or role of any law is to administer justice. And these three components are basically a facilitators to administer justice to the people in need. And in our case, the people who come from intellectual disabilities. So that is one kind of thought, and only then we'll able to, practice the principle of justice for all. Okay, so as we say that criminal justice system main basic principle is to deliver justice to all, so then which include people with disability themselves. So this is the background of my deliberation, my discussion. So firstly, let's talk about the criminal justice system in general, what are its components and how they are working, and then let's try to see that whether the person with disabilities are accommodated within this components, within these, structure. So if you see the practical situation, so like while talking about the first component, which is the law enforcement or the police administration, so as per this Bureau of Police Research and Development, so as per this data, as per their data, it says that there is a police ratio as for per persons, so it says that there used to be 195.39. Okay, this is the data I'm quoting from the Bureau of Police Research and Development. It says there must be 195.39 police personnel per lakh individuals. Okay, and then the real practice is somewhere around 150.78%, 150, 155, between 150 to 155 police personnel per lakh. Okay, so 1 lakh k against we need 195, but in existence we are about 155 police personnel, representing the 1 lakh individuals. On the other hand, if you see the UN reports, okay, or the international standards, it says that there need to be 222. This is the data based on UN recommendation, which says 222 police personnel against 1 lakh population or individuals. So this you can see the gap, the burden on police administration, or the lack of number dealing with the the masses, dealing with the population. These are the datas, or the figures based on some governmental organization. And if you see some independent reports, then in Indian scenario, the ratio again, fall down. It says, as per one independent study, it says 144 police officer per lakh individuals. So, so this is the first thing when we are talking about criminal justice system, and the police administration system or the law enforcement system is the very keen part of it. So if they are overburdened, that much overburdened, then how it will be possible for them to accommodate a person who need a specifications, okay, who has certain specific needs, okay. So this is first fundamental argument or question that we need to keep in mind. So this goes for both, where you are considering a person with intellectual disability as a victim and as well as a suspect. In both the situation, if you don't have equivalent number or and the well trained people in police department, then it will be really difficult, to really take up the matter or to administer justice for them. So this is the first, practice. And in fact, if you follow one survey, I remember it was conducted around 1819 or 1920, 2020 around. So it says that the trust of, Indian population, or whether they trust police department. So it says that the trust ratio is very less. It is 25% people, this is a journal open survey conducted, which says only 25% of people are trusting the police system against the army. So that percentage of trust is very higher on the side of army. So anyways, so these are, certain basic factors, basic indicators which tells us that our system, and in fact there are various several cases. I don't need not to go into that, those details. The police reform case, so where court has repetitively articulated or argued the constitution of certain commissions, okay, for police administration, so that they can look into the matter in terms of the transfer, appointment, and avoiding any political influence in police administration. But till date, in reality, in practice, that was not done. So that is one side of the story, the first component, the police administration or law enforcement. So lack of people in police department ultimately, leads into the delay in justice system or delay in your, framing of the basic investigation, formulating of your, the charge sheets, so on and so forth, and which ultimately impact obviously the person with intellectual disabilities, because they need some specific assistance, and certain training must be required on behalf of or on the part of police people for that. But if you don't have that equivalent number and adequate number, then automatically it will gonna, leave a kind of a gap. So this is first argument which I would like to, raise or want to articulate on. The second is the second component, which is the court system. So whether our court system are, efficient. When I'm saying efficient, I am saying in terms of number. So if you see, in I guess roughly there is like 18 judges per 1 million population. Judges looking after 1 million population. You can see directly the overburdening judiciary, overburden that judiciary is facing. So in this particular scenario, how it is possible for a judge to give a individual, attention to a case related to person or with disabilities. And that is the reason, in various studies conducted by different NGOs, different organizations all across the globe, which indicates that because of lack of infrastructure in courts, which in that infrastructure include that human resource as well as the physical infrastructure, because of its lacking, the person with intellectual disabilities or socio-psycho disabilities, or even person with disabilities in general, were unable to access these courts, okay, or unable to, communicate their hardships to the courts, and as a result their cases, their matter, they generally it remains outside the court premise. So if we need to develop a inclusive model of legal administration or justice administration, so we need to think on this particular aspect. And recently, if you remember, the honorable justice Chandrachud, in many of his speeches, in many of his writings, he used to put a keen as argument or keen interest in making the courtrooms accessible to persons with disabilities. In fact, there is recently a committee was constituted by Supreme Court, which is conducting an audit, accessibility audit of the Supreme Court. So the idea is to that how to make the court accessible, wo to who are physically, in the form of physical, but then at the same time you need, as I said, the accessibility in various other perspectives. So particularly, if I may quote the accessibility to legal language, so the language of our laws, particularly the criminal laws, whether that language is accessible to a person with intellectual disabilities or people with learning and mental disabilities. No, it itself, in fact, for a common man, generally for a common man, the language of law is not accessible. It is very inaccessible. It is very complicated. So if this is the case, then just imagine a case for a person with intellectual disabilities. Because of his or her stigmatized societal pressures, because of all those reasons, that person is unable to acquire the basic knowledge, basic education, and that is the result that he ultimately become the kind of a segregated part of a society. And in that situation, if the language of law itself is a complicated, so then it become very, very difficult for one to access. So the best example one may talk about is about sign language. Just imagine how many courts are using or are equivalent or equipped with the techniques of sign language or any other kind of communication. For instance, for person with intellectual or learning disabilities or mental disabilities, many times they were unable to communicate, to speak. They also have the disabilities in many other forms, so where they are unable to communicate or speak. So there is something called a facilitative communication, so where one has to facilitate the communicative skills or communication for them or with them. But do we have that infrastructure? Okay, do we have the people available on those particular ways, so where you need a special people who are trained in those communications? So the answer is again no, that we don't have that many people who are communicating on these, or are able to communicate on these level. So therefore the principle, the foundational principle of criminal justice, which means that the justice for all does not seems like practically feasible, or it's working in practice. So particularly when we are talking about the person with intellectual disabilities or person with disability. So this is the result, and this is the reason that we use to create a vulnerability. Okay, therefore the person belonging to any kind of disability or any diversity will automatically become vulnerable. So when I'm saying vulnerable, why? Because he does not have the access to the police administration, he does not have the access to the court system, and there are no one to facilitate his or her communication, to communicate to him. So this is what I always name as the constructed vulnerability. It is not the natural vulnerability, it is the constructed vulnerability, because of the reason that I'm unable to communicate. Okay, so this is something, one very important and fundamental aspect which one has to keep in mind. And when I am looking at the human right perspective to it, because the title of my talk is the pathway of into the criminal justice system and person with intellectual disabilities and human right perspective. So criminal justice system to a greater extent is connected to human rights. Just go back to the Magna Carta, the section 38 of Magna Carta, if I quote, or if I remember recall, it tells about that no officer, no legal official shall put anyone to law or to arrest any one person without any reason. The writ of habeas corpus is the basically the outcome of section 38, and that you cannot take away someone without legal reason, without valid reason. So what it means that the foundation of criminal justice system is ultimately is the human rights or the fundamental rights. So if you are unable to create an environment which is really accessible to person with disabilities, then it is definitely going to create a gap or between the human rights and the criminal justice system. And ultimately the victim is the person with disability, because of all those constructed factors, constructed barriers, he or she is unable to communicate or to get access to the system of justice or criminal justice system. So this is one such idea. In fact, I can recommend this one book on this particular area. There is this one book titled as Disability, Criminal Justice and Law. Okay, so this is published by Routledge publication. It's one of the recent book, Disability, Criminal Justice and Law. So where there are different essays on the point that what is the relation between these three things and what are the barriers and how to overcome it. So anyways, so this is the idea about the courts. And when I'm talking about courts, so I'll be concentrating more on this part, court system and access to justice for people with intellectual disabilities or learning disabilities. So my first point was legal education, whether our legal education is accessible to people with disabilities. Okay, so I gave you already the example of that lack of sign language interpreters in court many a time leads to problems. Many a time they are unable to communicate. So that is one idea, and particularly there are several cases on this part where courts were reluctant to take the testimony of a victim with disability, victim with cerebral palsy, or victim with intellectual socio-psycho disabilities or any kind of disabilities, where they were unable to communicate in the so-called normal language or normal way. So that is something very, very colonial understanding of law or language, because language then became the barrier. On the other hand, you just think of this point. Otherwise, we always say that language is the facilitator of communication, where we can communicate, we can express. But in these particular cases, language itself become the barrier, because if I don't have the skills or the techniques to speak, or the particular language, for that matter the English language, I am unable to pronounce clearly, I am unable to deliberate or express through that particular language, then it will becoming a barrier to me, because my entry to the justice system or the criminal justice system is through this language. So language is the entry pass or the door. Only then I'll, because either I have to write or I have to communicate. If I'm unable to do that, then how I'll be communicating? And the same thing goes when I have to communicate it to the people around me, or my relative, because they again struggle, many times they also struggle. So that is one point. And if I'm a single individual, if I don't have any family member with me, then it does not mean that I am there to suffer any discrimination or any injury, because simply of the reason that the people on the other side are unable to understand or unable to communicate with me. So this is what I'm naming as a colonial understanding of law and language, then which we have fixed into a particular binaries. So something is good, uska opposite is best, bad, and accordingly the entire structure has been designed. So when we talk about person with intellectual disabilities, so there are very many examples. In fact, I did some of the case studies, some of the literature of cases where a person with intellectual disabilities or people with socio-psycho or mental disabilities were sexually assaulted. But because they were unable to communicate to the police or to the courts, then it became very difficult. In fact, I remember a case study of state of West Bengal, where a woman with cerebral palsy and some intellectual, so socio-psycho disabilities, was sexually assaulted by one of her neighbor. And when this idea was communicated somehow by her to her mother, they approached the police system, and the case was registered, and gradually it reaches to the court. So during the court proceedings, she has to give her testimony, and while recording her testimony, she was unable to speak the adult language or the formal language, as I just mentioned earlier. So, and judge was very reluctant. He said that I can only register your testimony if you will able to communicate it in a formal language, in a proper language. So in fact, the women with intellectual disabilities and the cerebral palsy, she was you know trying to state or trying to communicate that the bad person has touched her with his susu. The word she used is susu, so the word which we used to refer, which kids used to refer generally. And the court was reluctant to take this word on record or to register a testimony on that basis. And he simply rejected her and asked the mother or the other guardians to come next time prepared, and then only I'll be registering the testimony. So this is the attitude. And there are several unheard and untold stories of these kind of experiences, which ultimately make law as the biggest hurdle, or you can say the barrier, in the right discourses for people with intellectual and learning disabilities. Okay. And there is nothing, so it's ultimately, when you are interpreting it, you are doing it from your own perspective, as a law person, as a law as a lawyer, or as a judge. So this is one such illustration I'm sharing with you. In fact, there is this very interesting, very another case of from United States, and it is very popular case, again related to sexual assault. Okay. So I'm basically focusing the as an illustration from the cases which related to sexual rights violation or sexual assault against people with socio-psycho disabilities, or people with mental disabilities or learning disabilities or intellectual disabilities for that matter. So this another case which I'm about to refer is a case named Anna Stubblefield case. Anna Stubblefield. Okay, Stubblefield. So this is again very interesting case, as per the facts are concerned. So in this case, there is a adult boy named DJ. Okay, it is a changed name. It's not his real name. So his name is DJ. So he is also, is of a disability. He's having multiple disabilities, and I'm not using the word suffering from disabilities, because for me it again leads to a very narrower perspective. Anyways, so what the point is that is having multiple disabilities. Okay, which include some sort of communication disabilities, learning disabilities, intellectual disabilities. So the crux of the facts are that he's unable to communicate in either way. He can't raise his hands or arms, or point out his eyes at something, or to communicate मतलब किसी भी तरह से, either any from facial expression or from any hand or any physical expression. He was lacking all such expressions, and his learning skills or his that IQ is again very low, which is again very the ableist expression of in of examining or testing person's capacity. So I'm totally against all those fundamental rules, so-called fundamental rules. So in this particular example, okay, his brother was a student at some university, and he attended a lecture from a professor, So Anna Stubblefield, she was a professor of philosophy, and she was also expert of a facilitative communication. Okay, the facilitative communication is a communication through which we can assist a person with intellectual disabilities, learning disabilities, or any kind of disabilities where person is unable to communicate, in a proper manner, so called proper manner. So he came to know about the professor, and he approached her after her lecture and requested her and told her about his brother DJ, that who is having these multiple disabilities. And she agreed to that she will be the tutor, the personal tutor to DJ, and she started giving training to DJ in facilitative communication. So facilitative communication is something that, you need to assist DJ under his elbow in like this, and then somehow he started pointing out at things. तो मतलब उस तरह से थोड़ा सा he is able to communicate. Okay, now what happened that once these facilitative communications courses were going on, or trainings were going on, so then gradually they developed a relationship among themselves, and they decided that they will want to marry. Okay, so Professor Anna said that I would like to marry DJ. Okay, ignoring her all kind of disability, and which is something, very important in particularly in our societies, where we think of compatibility as per the bodies, shape, size, are lot of, different compatibility modes are there, but she ignored all those things, and she wanted to start a new journey of life with DJ. And for this reason, they both, in presence of DJ, she communicated this to her parents, DJ's parents, okay, to his parents, that this is what they decided. And DJ's parents, they filed a criminal case against Hannah Stubblefield on the ground that DJ is unable to communicate. And if he's unable to communicate, he cannot give consent to any relationship, any, sexual relationship, or any lovely relationship for that matter. And the case of sexual assault was registered against Professor Anna. Now see the irony. The professor who is the activist, disability right activist, a professor of philosophy, and the professor who is trained in the facilitative communication, who is there to assist people with other disabilities, multiple disabilities, to communicate. She was, or she is now become the perpetrator, or she has become or branded as the criminal in this particular case. Now this case, when this matter reaches to the case, the court has, rejected all her contentions, or her the testimonies or records, which states that the DJ is able to communicate through facilitative communication. So firstly, court believes that in our evidence law, or in our criminal law, we don't believe facilitative communication as a legitimate mode of communication. It is not a communication. Eh? And they said that it is someone else who is communicating on behalf of DJ. It's not he himself. The, interesting and the funny part is that she has, invited certain independent experts from Australia to justify her point that facilitative communication is a valid communication and it is acceptable throughout the world. But the court, on the other hand, they bring in their own experts. So their court's experts said that no, facilitative communication is not the right communication. On the other hand, these independent communicators, or the, the experts, they said that yes, it is a important part of communication. So it is accepted part of communication. So there was this clash of two opinions, and court has outrageously, rejected her contention, the independent experts opinion, and relied on state's expert opinion, or their own experts opinion, and thereby sentenced her for imprisonment. Now in this case, the DJ became the victim of the law, and the professor, she became the, the culprit, or the suspect, But in both the ways, DJ at the same time he is a victim. He's double victimization. He has went through the double victimization. That it is the law which says that he is unable to communicate and there is no need for him for any relationship because of his disabilities. It is their opinion, and that way they constructed this entire narrative. So this is a kind of a approach which generally criminal law has towards people with disabilities, or people with more about with towards people with intellectual and you know people with mental disabilities. This is called the overprotectiveness of criminal law, or overprotectiveness of criminal justice system, that which says that criminal law is a overprotective. Okay, so it says that the criminal law is overprotective. तो जब आप ओवर प्रोटेक्शन कर रहे हो, ओवर प्रोटेक्टिवनेस की बात कर रहे हो, तो देन I as an individual does not have any say. Okay, so this is one of the biggest issue when we talk about criminal justice system and the the people with intellectual and disability. So this is the gross violation of their human rights, their rights of autonomy, their rights of freedom of choices. So it's someone who is deciding. It is the court, or it is the someone else who is deciding. The reason is the narrative which I started with, because lack of expert people, or the people who are already overburdened, who don't have the time to get expertise or to think about the cases or the issues related to persons with intellectual and socio-psycho disabilities. So this is the one such example, and it itself leads us to a very strong argument, a very powerful narrative, that whether it is okay to deal in these situation, to deal with in such way, in such area. So basically what is the story at the hand is that the criminal justice system or criminal law does not consider the legal capacity of person with disabilities in general, and person with socio-psycho disabilities or intellectual disabilities in particular. This it says that person with disabilities or mental disabilities or intellectual disabilities lack legal capacity. When I'm saying legal capacity, means you don't have the capacity to approach justice, to approach court. If I am not legally capable or capable enough to approach court, how will I access justice? So this is very clear idea. But if you see the development on international law, okay, or from the sides of international law, under international laws, we have several different laws. Particularly if I can recollect from conventions on right of persons with disability, CRPD, UN CRPD, it says that state parties shall prohibit all discrimination on the basis of disability and guarantee to person with disability equal and effective legal protection against discrimination of all ground, on all ground. This is article 5th of CRPD. So you cannot discriminate person with disability, and you need to give them all kind of legal protection. But on the other hand, what our criminal justice system says, that a person with disability does not have legal capacity, so someone has to approach on his or her behalf to the court, and only then the case can be taken up. So this is a particular international law on disability, UN convention. Apart from this particular law, if you talk about the general international laws, so various conventions, for instance, International Covenant on of Economic and Social and Cultural Rights, ICESCR, or ICCPR, both those covenants. In their journal comments, the Committee on Economic, Social and Cultural Right, in its journal comment number 5, it says that person with disabilities shall face no discrimination. There shall not be any discrimination in economic, social, and cultural rights towards person with disabilities. Similarly, this ICESCR, it again prohibits discrimination on the ground of disability. Okay, and says that they shall not be considered as other. So this is something important word. I deliberately wanted to mention these ICCPR and these conventions, and particularly their journal comment number 5 and journal comment number 20, because in journal laws, international law as well, it says that there shall not be any discrimination, and they use the word other. One should not treat a person with disability as other. So the word other is very significant here for us, that whether criminal law otherize the person with intellectual disabilities, the otherization of person with intellectual disability. If there is a otherization say matlab, or it means that where it is someone else who is deciding for other. That is why otherization, that it is other who is deciding for me as a person with intellectual disability. So if this is the case, as long as this case is continued, or this mechanism is continued, and in generally in our criminal justice system, for person with disabilities or people with socio-psycho and intellectual disabilities, we always follow the otherization method or otherized method, that it is the state, or it is the judges, or it is the activist or the lawyers, they are deciding for the person with intellectual or socio-psycho disabilities. In the name of what they call this whole otherization process, they say it is in the best interest of so and so person. That's why we decided. That's why we denied DJ the right or to marry, because he is a person with intellectual disabilities. And it is in his best interest. Who is deciding this best interest? We as a court, we as a state, we as a system. But when you are doing this, you are denying the autonomy, the choice, the freedom, the dignity of to that individual in concern, and which is the immediately the gross violation of human rights or basic universal principles of justice and human rights. In fact, I would like to substantiate this argument with another interesting case, and case again is from India, Suchitra Srivastav versus Chandigarh administration. I hope you might have read this case, heard this case. This is old case, but quite important and very relevant for our particular discussion for the today, for this particular topic. Now, if you see the Suchitra Srivastava case, what are the facts? Very briefly, if I can narrate, the fact says that a person with, mental disability or socio-psycho disabilities or intellectual disabilities, she's a orphan, okay, a girl, and living in a rehabilitation center. Okay, because she's an orphan and suffering from intellectual and mental disabilities, and therefore she's abandoned kid, and she's living in a reformation center. So earlier, initially, she was there in Delhi. From there, she was, taken to the Chandigarh, and in Chandigarh, particularly in one organization which is run by government or Chandigarh administration. So she was staying there, living there for a couple of years. So she was sexually assaulted by one of the security guard or one of the caretaker of that rehabilitation center. And after this sexual assault, she got pregnant, and her pregnancy came to the knowledge only in very advanced stage. Okay, in very advanced stage of her pregnancy. And when this came to know, then immediately the authorities of that institution, they constituted a committee which consists of some medical experts, some psychologists, and various other members, and they tried investigating that what is the matter and what is the stage of her pregnancy and everything. They tried to communicate to her that whether she's aware that she is pregnant at that point or not. So all set of communications were done. And then, while these things were going on, the institution framed a mind or opinion that we should go ahead with abortion. We should not continue with the, you know, the this particular pregnancy, and we should abort the baby. And for that reason, they constituted a medical board, okay, of from a government hospital, sector 32 of Chandigarh. They constituted this medical board. Now this medical board has, you know investigated many things, has deliberated on many things. So, and they investigated and they found that the girl is lack of IQ. She don't know to identify or the differentiate between what is a legitimate child, what is illegitimate child, what it means to be a child within marriage and child without marriage. She's unable to identify the money, the currency value. So all those, parameters were laid down, and accordingly medical board suggested that she should not continue with the pregnancy because it will not be in her interest. The word is again in her interest. And they submitted the report. So while before going ahead with this abortion, the institution, the Chandigarh administration, they approached the High Court, Honorable High Court of Punjab and Haryana, okay, Punjab and Haryana High Court. And then this investigation started, and in court, court again constituted the, another medical board, this time constituted of a PGI, Post Graduation Institute of Medical Sciences, Chandigarh, PGI Chandigarh. So in PGI Chandigarh, this time the medical board again comes up with the same kind of conclusions. So while putting these conclusion on record, court again, supported the argument and said that we should not, there is no need to interpret MTP Act, the Medically Termination of Pregnancy Act, in its literal sense, because as per the act, it says that in case if you want to abort a child in womb, you need to get the consent of a mother. Okay, but court said that because in her interest it is not feasible for her to continue with the delivery or continue with the pregnancy, so therefore she should, and court acted as a friend, friend in her interest. So peripatria principle, so where court has entered into the shoe of a friend and tried assisting the individual and relying primarily on those evidences, those reports, which are coming from the medical experts, and said that if she's orphan, she has no legitimate child, it will be very difficult for her to raise that child, and she don't have any economic sources, and all those, so background was constructed while delivering the judgment. But when this was done, then immediately a petition, filed specially petition was filed in Supreme Court, and thankfully Supreme Court has, accepted that petition as an emergency case, because the time of, the time which is available under MTP Act was almost about to complete or end. So therefore this immediate hearing was given to the case, and Supreme Court was of the opinion that no, you cannot ignore MTP Act, and MTP Act says that the consent of mother is important, then it is important, you need to, take her consent. And moreover, she is suffering from a mental disability or intellectual disability which is of a mild nature. So there used to be time when she do her things very normally, and then gradually she used to go through her that phase of disability or mental disability. And court has, overruled High Court's opinion and allowed her to continue with her pregnancy. Now, in all this scenario, in all this story, what is important for us to understand is that a individual's life was discussed, deliberated at a public sphere, at a public place, so everyone was deliberating on her, through the different laws perspective, from criminal law perspective, from constitutional law perspective. But in overall, no one has, give concern to her autonomy, her, conditioning, so which she is going through. So no one took her opinion on this. So therefore, so the otherization is there. So this is what my point is, that if we talk about criminal justice system, the otherization persists, it continues. So as long as we are unable to overcome this otherization or to remove this otherization, we are unable to, you know really facilitate criminal justice for persons with intellectual disabilities. So I think there is some noise is going on. Hello.
Hello, sir.
Yeah. So this is
Yes, sir.
what I think. So shall I continue, or should I wind up?
No, sir. Thank you so much. It's
Yeah.
really informative session, but the session is open for question answer round, sir. So
Yeah.
we have some
Sure.
questions from the participants. If you allow, we may put the
Please,
questions.
please, please, please.
So one is the what are the key human rights challenges faced by individuals with intellectual disabilities when they come into contact with the criminal justice system?
Hmm. Okay. So 1 second. Yeah. So thank you for this question. It is, important, interesting question. So as you said, the criminal justice and person with intellectual disabilities. So the challenges, as I told you, very first challenge is accessibility to
Okay,
the
sir.
criminal justice system. If it is not accessible for you, then it's very difficult. Accessibility in terms of infrastructure, in terms of communication, because many time it has been found and observed that a person who is the only, eyewitness, the victim himself or herself is the eyewitness, but because of unable to communicate, he is, unable to deliberate on the matter. So that is first challenge, and that need to be overcome, ignored, through creating an environment which is really inclusive, while training people with court system or prison system to deal with the issues. Yeah, I think that would be the answer.
Yes, sir. Yes, sir. Sir, next question is how does the criminal justice system currently address the specific needs and vulnerabilities of the individual with intellectual disabilities?
Yeah, so I think the answer to this question is negative from my understanding in my side, that
Yes.
our existing criminal justice system is unable to address equitably and adequately. I'm using two important terms. Equitably means unable to, give them the rights which they deserve, and adequately because their lack of training and awareness. So I can say that the criminal justice system is still lack of, sensitization. We need to make criminal justice system more sensitive towards people with intellectual disabilities.
Yes, sir. So your lecture is comprehensive of all about these topics. But next one question is how does the investigative process arrest the processes of arrest, detention, and questioning impact the individuals with intellectual disabilities? And are the
Yeah.
human rights violation associated with these stages?
Interesting, very important question. So as I
Yes.
said, when I was giving you the reference of this West Bengal case, where judge was reluctant to admit the testimony of a person who is suffering from who was sexually assaulted. So similarly, there were many such reported cases where police personnel used to misbehave with the people belonging to the various kind of disabilities, intellectual disabilities, because the person with intellectual disabilities are unable to communicate in a so-called the normal manner. So and therefore they don't rely on their testimony. First, the investigating officer, firstly they don't trust and rely on their testimony, and they went to seek information from other people around. So others version about an incident is always very limited and very ableistic oriented, so which they
Yes.
ignore, and which is direct violation of their fundamental right and their human rights. So because they were unable to get justice, because it is others who were doing everything for them, and their testimonies were rejected, they were not considered as a trustworthy. In fact, there are several empirical studies on this point, and those studies indicates that police personnel and investigator officers rely very less on people with intellectual disabilities, even if they themselves are victim of a crime. Yeah.
Sir, one more question, last this one. What are the barriers that individuals with intellectual disabilities face trying to access legal presentation and support during criminal proceedings?
Okay, so first point, as I told you, the legal capacity, so the most important thing, that till now the court, want someone else to represent themselves. So if I can recollect यहाँ पे one story or one example of state of Tamil Nadu. So in 2002, there was, a fire was broken up in a rehabilitation center where people with mental disabilities and intellectual disabilities were kept, and these people were chained. Okay, this was the first time that the country came to know that how we treat people with intellectual disabilities, and how they were treated in the care centers or care homes or rehabilitation centers. So these people were chained, and that is the reason they were unable to escape, and all of them, they were burned to death. So when this matter taken up by the people in journal, it is, other activists, other people who started investigating, writing articles on this, but they were not given, consideration, their own opinion, their own experiences, so where person with disabilities themselves can speak. So therefore the point is the legal capacity is lacking. So if you provide the access, abhi the idea is, there is a term used is substitutive decision making. Okay, there is a substitution. So suppose if I am a person with mental disability, so someone else is deciding on my part, representing me in court, so it is called substitutive. But as per United Nations Convention, it's on person with disability, it says there needs need to have a supportive decision making. We should support, not substitute. Okay, so in this Tamil Nadu wala case mein, there was, the case was dealt by the in a substitutive manner. Someone else were fighting, deliberating. Okay, and the survivors of that incident, their testimonies, their arguments were not recorded.
Okay, sir. Thank you so much, sir. This is really an informative session. Thank you so much for your kind knowledge, for sharing with
Yeah.
us. Well, thank you on behalf of whole Faculty of Law, Integral University.
Thank you so much, Suma ma'am. Yeah, thank you.